Council assisting us whether we maintain our non-publication or request in relation to the issue I raised just before the break, because we have instructions my commitment on Monday has nothing to do with these proceedings. I'm actually in the matter before Justice Barr, and that was the only day he had available because of his previous commitments in other springs. And I couldn't do anything about it. And his part heard only for tomorrow, over Monday.
The interim non-publication order made just before the break is lifted. Yes, Dr. Dwyer.
Your Honour, I propose just to deal briefly with some issues and then expand on submissions on Monday when we've had the benefit of receiving some further submissions on the jurisdictional issue, the scope issue. And I'm told by my learned friends at the bar table that they do not wish to provide any comprehensive oral submissions now and will take up Your Honour's opportunity to come back on Monday.
So Monday will also be set aside for submissions?
Yes.
And we won't be commencing witnesses until later in the week?
Yes, Your Honour.
Thank you.
Your Honour, a document has been distributed. If I might hand up a copy to Your Honour, it's relevant text messages from the extraction from Constable Rolfe's phone. It involves text exchanges between Constable Rolfe and other officers, both prior to and immediately after Kumanjayi's death. I ask that it be marked MFI-D. C?
C.
C.
Yes.
C? What's C?
Are you asking for anything else in relation?
Yes, I am, Your Honour. I note that contains set out a number of the text messages that were sent from Constable Rolfe to other officers in the Northern Territory Police Force, primarily based in Alice Springs. And it has both the names of the other officers that text messages were sent to, and of course some text messages that were sent back to Constable Rolfe, and also the content of those messages. And I asked for a non-publication order, an interim non-publication order over that document at this stage in order to preserve the rights of parties at the bar table.
Yes, so I now make an interim non-publication order over the document marked MFIC and also noted as a counsel assisting the coroner's aid memoir in relation to messages from an Apple iPhone.
Thank you, Your Honour. And Your Honour, just to make it clear, it's not suggested that they are all of the text messages that might be relevant to Your Honour's inquiries in this inquest. They are merely an example of some of the text messages that I will make further submissions on Monday as to their relevance to the scope of Your Honour's inquiries. They go well beyond just the two text messages that were sought to be relied on by the prosecution at trial, and they involve other officers, not just Constable Rolfe. And of course, by virtue of a non-publication order over that document, there's a non-publication order over the names of other officers that were communicated with at that time. There's just one other issue that I just seek to deal with today, Your Honour, and it's primarily because of the purpose of informing the public too about the nature of coronial proceedings, and to clarify one issue, particularly while Mr Edwardson is here at the bar table today in case anything further is sought to be said on that. I will distribute a short note about this issue today. The purpose of these submissions is just to put on the record Counsel Assisting's position with respect to the assertion raised orally today that it's not permissible or proper for a coroner to inquire into the facts underlying the criminal offence of which a person has been acquitted, because to do so would be to go beyond the acquittal, if I've correctly understood Learned Senior Counsel's position on that. In fact, a coronial court looking into the facts of a tragic death, including police shootings, after a criminal trial can be done. Analysis and investigation of the facts is permitted and has been permitted on a significant number of occasions in Australia in different jurisdictions dealing with similar acts. An example of that is the case of, let's get the full citation, for my friends, an inquest into the death of Vlado Misic, M-I-C-E-T-I-C, apologise if I've mispronounced that, scope of inquest ruling, Coroner's Court, Victoria, Coroner Jamieson, 19th of August 2019. And of course we can provide a copy of these to my learned friends. But in that case, it was dealing with a police officer who had the death of a man who'd been killed by a police officer. An officer shot and killed a motorist, and that officer was then tried and acquitted of murder. Following the acquittal, an inquest into the death was resumed, and among the issues identified on the issues list were the immediate circumstances that led up to the death of the motorist from the gunshot injuries received, and whether the use of force against that motorist was consistent with the relevant Victoria Police policies, practices and training, and was otherwise reasonable in the circumstances. Those appearing on behalf of the officer objected to those issues on the basis that they were not within the scope of the inquest. It was said in effect that to inquire into the reasonableness of the constable's response to the threat posed by the motorist had been already the subject of the Supreme Court criminal trial. The coroner rejected that submission. He noted, of course, that he must not include in his findings or comment any statement that a person is or may be guilty of an offence. And that, of course, is the same situation with respect to the Northern Territory Act. But he did not accept that an inquiry into the factual circumstances in which the constable fired his weapon at the motorist was necessarily an inquiry into the commission of a criminal offence, because the coroner's perspective is quite different from a criminal trial. He noted that there was substantially potentially relevant evidence before him that was not available to the jury, and he was not bound by the rules of evidence. And that may well be the position, certainly in terms of additional information, that will be the position before Your Honour. And of course the rules of evidence do not apply in these proceedings either. He noted that it would be open to interested parties to make submissions about the extent to which definitive findings could be made on the question of non-lethal force options or related topics. And he said these words, Your Honour, which I'll read in full because they're so important for us all in understanding the nature of the coronial proceedings. The nature, object and outcome of an inquest is substantially very different to the nature, object and outcome of a criminal trial. Coroners do not adjudicate issues inter partes, and their findings do not determine legal rights. Rather, the purpose of the coroner's investigation is to determine what happened. In seeking to determine what happened, I must keep in mind the preventative and public health purposes of coronial investigations. The circumstances of Vlado's death have implications for the training and support of police officers in their interactions and in dealing with people like Vlado. They also have implications for the safety of persons who interact with police and the broader community. This note on this issue is being distributed for the benefit of my learned friends now. Perhaps then all I need say in addition is that contained within this note are 4 cases where a similar issue has arisen, and they are coronial inquests in which coroners have examined the facts underlying an offence of which a person has been acquitted. The coroner is not bound by a criminal verdict, but is able to make findings on the evidence presented irrespective of a previous determination, mindful, however, of course, of the restrictions under the Act of making any finding that someone is guilty of a criminal offence.
Yes.
Thank you, Your Honour. If I can continue submissions on Monday.
Yes. So thank you, Dr. Dwyer. We will now adjourn, if there's nothing further from the bar table, to 9:30 on Monday.